So is it possible to sue for patent infringement? Yes. While patent is under patent pending status. Okay. It's always possible to enter suit, allege certain claims.
That's what I always tell clients. You can sue anyone for anything.
You can. So definitely the answer is yes, it's possible. Should you is probably the better question. And the answer is no. Unfortunately, while an application is pending, you have no rights. And it's kind of a heartbreaker to tell clients this, that there's no legal rights until the patent is granted. Now, you do have some sort of pseudo rights, we call them. You've got the ability to put actual infringers, potential infringers on notice.
And what's the benefit of that? Why would you want to put them on notice?
Big benefit. If they decide to, after seeing that notice, and you can sort of get one of those read receipts or even a certified mail, right, with a signature confirming their receipt, and they continue to infringe as a willful infringer. And now you can allege and negotiate additional damages up to treble damages. It's called
treble damages and attorney's fees.
Yes, getting big trouble. And otherwise, it's a good thing to do. The patent office does it for you by publishing your patent application. But it's
constructed notice.
Constructed, yeah. And it's sort of, you want to be able to send that to them or really notify. And a lot of times that's done through things like cease and desist letters or a notice letter. And you can do that. So unfortunately, no rights to actually threaten and, assert your allegations in federal court or even at the ITC, the Customs Border Protection. You do have to wait till your patent gets granted.
Same with trademark side. Exact same.
Trademarks. Okay.
You can't really do any enforcement until you have that registration certificate in hand.